Good morning. Be seated, please. I'd like to welcome everybody. This is sort of a special proceeding for us in the sense that we are live streaming this to the law students and faculty and other members of the legal community at the University of Arizona Law School. We try and get over there at least once a year for oral argument. Once again this year, though, we're doing it virtually given lingering concerns about COVID-19 issues or the potential for those. So hopefully next year we'll be able to get over there in person again. Before I call the case, I will indicate that at the conclusion of the arguments today, there is an opportunity for the law students or anyone else over there at U of A to ask questions of the court. When we go to the question and answer session, counsel, you're welcome to stay if you like. Students may want to ask you questions. Also, Judge Starring is our vice chief, so I'm going to defer to him, and he will be sort of moderating the Q&A, and he'll have some additional words about any restrictions on the kinds of questions that can be asked and that sort of thing. So with that, this is the date and time for oral argument in the matter of Rodgers versus Huckelberry, excuse me. Our case number is CV 2021-0072. Counsel, if you could state your appearances, please.
Tim Sandefur, representing the taxpayers, Your Honor.
Good morning. Mary O'Grady, representing the appellees, Pima County Administrator, Pima County Board of Supervisors.
Thank you. And counsel, just so it's clear, if it's absolutely your choice whether to wear a mask or not while making your argument, whatever you're more comfortable with. Each side will have 25 minutes for argument. You both have acknowledged you've received the draft decision that this court issued, correct? Okay. And as noted on that draft decision, it has been prepared by one judge and one judge only, and the draft may be changed entirely or in part after argument. With that, Mr. Sandefur, if you're ready to proceed.
Thank you, Your Honor. May it please the court. Pima County arranged a package of subsidies which it designed specifically to benefit a single private business, Worldview, in order, as the county administrator said, to, quote, front-end capitalization of Worldview. It spent $15 million to design and build a custom-made office building and a balloon manufacturing facility and a launch pad to Worldview specifications, and then structured the monthly payments so that Worldview pays the county back for the construction costs. And it gave Worldview a $4 million tax exemption for which Worldview pays nothing. And then in 20 years, when the building is still worth...
Let me interrupt there for a minute, because the $4 million tax exemption, is there really a tax exemption if by the operation of state law, this particular type of operation isn't subject to a tax?
Yes, Your Honor, it is. It does not matter, as the draft opinion holds, that the tax exemption exists by operation of law. All tax exemptions exist by operation of law. And we know that the gift clause applies to tax exemptions that are granted to private entities because the courts have said so in Panamalco, in Maricopa County, and because as a matter of common sense, eliminating a liability is the equivalent of creating an asset. There's a case called Roland versus State Loan Board, which I'm sorry to say is not in the brief, but the court can find it at 24 Arizona 116, that says forgiving a debt to the government is the equivalent of a gift. And in the Nelson case, the court said that the purpose of the gift clause is to prohibit the government from giving cash or, quote, other valuable advantages, end quote, to a private entity. So,
but here it's the state that's giving the exemption to whoever's using the county property. The county has no control over whether or not this GIPLET applies.
I think that's not correct, Your Honor. That's not correct because the county owns the property to which the GIPLET statute applies and arranged this deal in order to grant that benefit to Worldview specifically. It's not accurate to say that the county doesn't own the GIPLET. Of course it owns the GIPLET. Nobody else owns the GIPLET. And the entire arrangement contemplated giving that benefit to Worldview. That's why it appears in the contract itself. Now, again, all tax exemptions operate by function of law and operate by function of state law. And there's certainly no precedent that says that therefore they are off limits to gift clause examination. Remember that the gift clause doesn't prohibit just expenditures, and the draft opinion suggests that it does. But that's not correct. The gift clause prohibits aid by subsidy or otherwise. That's very broad language. And we know from the history, we go into this in the opening brief, the history is that tax exemptions are one of the leading reasons for the drafting of the gift clause. The Montana framers who first wrote this language had tax exemptions for railroad companies foremost in their minds when they wrote that language, and Arizona copied it. This, in principle, is indistinguishable from the kind of tax subsidies to private industry that generated the gift clause in the first place. The county takes a position that, well, it's an indirect benefit. And it bases that on a misreading of Shires and Turkin. What those cases said was that the tax revenue, the anticipated tax revenue to the government resulting from a private business's operations was too abstract and, of course, was a pre-existing legal duty. So it couldn't count as consideration under the gift clause. That's not what's at issue here. What's at issue here is the elimination of a liability that Worldview would otherwise have had to pay, which was the goal and the purpose of the drafting of this contract language. So of course, this is a gift that the county has arranged for Worldview to benefit. And remember that the correct analysis here is to compare the give and the get from the public. What is the public giving? What is the public getting? Here it's giving its $4 million tax exemption. What is it getting? To answer that question, we have to look at this entire contract. I want to emphasize this.
Mr. Sandefur, let me I think you were segueing perfectly into it, but this deal has a lot of parts, a lot of moving parts, and the law says we're supposed to look at it in a panoptic fashion. And I have a couple of questions, unless I'm wrong, I think both sides say if you look at it in a panoptic fashion, we win. Okay. When is the panoptic snapshot moment? The beginning? When the deal is initially made?
Yes, Your Honor. The panoptic moment is we look at this contract when the signatures are applied.
Okay. And how does one look at something in a panoptic fashion? Which presumably, I'm guessing you both have different views about that, because otherwise you wouldn't say you win if we look at it in a panoptic fashion. Is it to look at it panoptically? Is it to say we look at the outcome passes an overall test of legality without looking at semantics or labels, deal's okay? Or to look at it panoptically, are we looking at the deal in its entirety and looking at its elements and deciding whether any particular element is illegal?
Well, Your Honor, the word panoptic means all-seeing, right? It means, and the cases have said, we look at all of the relevant factors and we focus on the realities of the transaction. And we look at the deal as a whole rather than using technicalities to tear it apart and ignore parts of that deal. And unfortunately, the draft opinion does just that. The draft opinion engages in technicalities to ignore parts of the deal, such as disregarding the GPLET tax exemption on the grounds that, well, it's a function of state law, even though we know that this deal was arranged so that Worldview would enjoy that benefit. Instead, what the court is supposed to do is it's supposed to look at the realities of the transaction as a whole and say, what's really going on here? This is a realistic, common sense analysis. And as part of that realistic, common sense analysis, there are two goals that the court pursues according to the precedent: protect the public fisc and prevent the giving of money or other valuable advantages to private companies.
So let me stop you again. You gave me a little different methodology of panoptic viewing than I would have expected from you on this one. What is it that you think, when we look at this in a panoptic fashion, makes this deal illegal?
The fact that the public is giving $20 million in value to Worldview and receiving in exchange for that $20 million, $11.75 million in benefits.
So that's a subsidy argument.
That is a subsidy or otherwise argument. And that otherwise word is really important because it's not just cash expenditures. It's by any form of aid in the form of tax exemptions or otherwise, and that by subsidy or otherwise means indirectly as well as directly. The Weinrich case from Montana explained that the phrase by subsidy or otherwise, Montana being the only other state that has that phrase or had it in its previous constitution, that phrase means directly or indirectly. And this is really important because the draft opinion attempts this distinction between loans and loan of credit. And that distinction falls apart really based on this by subsidy or otherwise language. That language says you can't do indirectly what you can't do directly.
The $11 million you mentioned, that's the value of the lease payment rights. Is that correct?
That is reduced to present value. If you could take what Worldview is supposed to pay and put it into a single bond and sell it on the open market, that's what that's worth. So that's a fair market value reduced to present value.
There's another figure where over the 20-year period, Worldview will pay I think, $24 million, something like that. Then there was a reduction that got down to 21 million.
Excuse me.
Understand?
Your Honor, to be honest, I don't quite follow the math in paragraph 35 of the opinion.
Okay, well, then let me ask you then a different question. If we're looking at it panoptically, your argument is in part that in the first 10 years of the lease, Worldview is paying a below market rent.
That's right, Your Honor.
The county, I think, says, well, but over the 20 years, it pays a market rent because it pays a higher than market rent.
That's right.
Continues. If we're looking at panoptically, can we say because the first 10 years would be an illegal subsidy, you have to throw out the deal? Or do we say, well, over the entirety of the 20 years, it's okay? That part's not a subsidy.
The answer is the first option, Your Honor, because if it were otherwise, there would be nothing in the Constitution to prohibit the government from leasing a piece of property to a private entity for 99 years for $1 a year, with the promise in the contract that in the 100th year, it'll pay a balloon payment to make up the difference. And that would ignore the realities of what would be really going on, which is a subsidy to that private business by subsidy or otherwise. So again, the realities of the transaction approach is a realistic approach that doesn't get hung up on technicalities and says, is the government really subsidizing private industry? And we know the answer to that is yes, because the county says so. The county said it was front-ending capitalization for Worldview. And that is a definition of giving startup capital to a private company. That is by definition a subsidy. And now I want to emphasize with my remaining time this attempted distinction between loan and loan of credit. This is an indirect loan of credit at least, even if we accept this distinction between a loan and a loan of credit. A loan of credit, I think we would all agree, a loan of credit is if I say to you, you can use my credit card to go down and buy stuff, right? This obviously wasn't that. The county didn't do that. What it said was it said, well, I'll use my credit card to go buy stuff. Then I'll turn around and lend it to you. And then you pay me back for that, and then I'll use that money to pay off my credit card bill. That's an indirect loan of credit. So even if we accept this idea of a distinction between one and the other, it still fails. Paragraph 11 of the draft opinion says, a loan of credit is allowing another party to use one's good reputation for solvency and reliability. It's exactly what happened here. The county used its reputation with U.S. Bank to obtain the loan in order to build the asset which it lends to Worldview, and then with the option, sell to Worldview for a fraction of its actual value in order to give startup capital to a private business as the county.
Could the county simply act as a bank and lend money to Worldview for a stated market interest rate?
Oh, if it were at a stated market interest rate, probably that would be if it came out to an equivalent and it wasn't a subsidy to a private business, that might be, but that's not the situation here. What happened?
Well, why don't we see that more often, rather than doing some convoluted transaction where the county has to own land, lease it back? Why don't counties simply lend money at market rate or something that's not grossly disproportionately below market rate to a private entity for economic development?
Well, Your Honor, the primary concern of the gift clause is to prohibit the subsidy of a private business. And what you find in a situation like this is that the county selected a single private beneficiary to obtain that loan. This isn't a situation where you have, a broadly applicable program that anybody can apply to and so forth. This is a situation where the county pre-selected this entity, went to the entity and said, here's a bundle of benefits that we can give you. Let's find a way to make this work in order to front-end capitalization of your operations. I mean, that's the definition of subsidy.
Mr. Sandefur, if this was open to, say, 10 participants instead of 1, does that make it constitutional?
Probably not, Your Honor, no.
So,
but the court doesn't need to get into this fine line drawing about how, general applicability and stuff, because here you have a single private, nobody else was eligible for any benefit under this program. Is this a loan? The obvious answer is, literally speaking, yes, it's a loan. The second question is it constitutional? To answer that question, the court applies the two factors that I mentioned before: protect the public fisc and prevent money or other valuable advantages from going to private companies. And here you have a situation where the county chose this private entity and said, we'll give you all this bundle of benefits in order that you can start up your operations, and we hope that you can pay us back in 20 years.
Mr. Sandefur, isn't it, I'm sorry. Excuse me. Loan its credit in aid of isn't language that lends itself really easily to a plain language analysis. What I'm thinking though, in the term of loan its credit, if you go back through the case law, there's these cases that go back 120, 130 years, and some of them, everybody talks about it being prohibited, but nobody ever really defines it. What it means to, maybe it was a term of art that was obvious to everybody in the 1870s. Loan its credit. In order to prevail on a loan its credit argument, don't you need to distinguish this from a bond situation?
I don't think so, Your Honor, because the clause goes on to prohibit by subsidy or otherwise. And that catch-all language means that we don't need to get into those kinds of technicalities, because the framers use this, and you're right, Your Honor, it doesn't lend itself to an easy reading, because in drafting this language, the framers were trying to be as comprehensive and emphatic as they could. That's why they use the word ever. Have you noticed that the clause says that neither the state nor the county shall ever give or lend its credit, etc.? That use of the word ever, what is the function of that word? The function of that word is to emphasize absolutely never, under any pretext or in any form, may the government subsidize private businesses with public taxpayer resources, which is what's going on here. And the cases that we've cited in the brief talk about, and from other states that have gotten into this, talk about these kinds of transactions in terms of loan of credit. The Lacilla versus Wenatchee case that's cited in the reply brief, for instance, the government was, quote, acting as a mere financing conduit for the private party's purchase of the theater site, which meant it was lending its credit. It specifically says that was a loan of credit. So that goes to Your Honor's question about, could the government just operate a bank? If it's engaging as a financing conduit for a private party obtaining this asset for its own private use, then that's probably a gift. Now, there might be other kinds of circumstances. We know that there are circumstances where if the government oversees the operations of the private entity to ensure that that private entity is engaged in a public purpose, that might be legitimate. But there are no such safeguards here, so it's not necessary to address that question. The North Miami case, this court's the draft opinion says that, and it's correct, that the North Miami case is very close to the facts we have here. Then the draft opinion says, but we're not going to follow that because the state of Florida amended its constitution afterwards. Well, we haven't amended our constitution afterwards. So, and I think our state Supreme Court has been quite clear that what was prohibited in 1912 by this clause is still prohibited today. Paragraph 36, I want to make sure to point this out. Paragraph 36 of the opinion says, even if we accept all these technicalities and distinctions, even if we engage in tearing apart the deal and throwing away the Jeeplet and so forth and so on, still the county is giving $4 million to Worldview, and that's okay. That's not okay. If $4 million isn't a gross disproportionality, what is? $4 million is not a small amount of money. That's the city of Tucson's entire budget for park maintenance. So it can't be the case that the government can simply subsidize. Now the draft opinion says, well, yes, but Worldview maintains the facility, and that has to be considered consideration. No, that doesn't count as consideration, because the only reason it's maintaining the facility is because it obtained it in the first place. Under that rationale, the government could buy me a $4 million mansion as long as I promise to maintain it. That would clearly be prohibited by the gift clause. Mostly, paragraph 36 fails, and 35 fail to recognize this transaction as a whole. They engage in technicalities to tear the contract apart by ignoring the $4 million Jeeplet, ignoring the $14 million remaining fee value in the building when Worldview obtains it, and then says, and $4 million is close enough. And that's contrary to what the precedent says.
Simply ignore the launch pad aspect of this deal, given that the appraisers couldn't do a market value analysis of it?
Well, the closest value we have about the launch pad is the construction cost of $2 million. And as explained in the brief, Worldview is the exclusive user of this as a matter of reality, because
Were there no comparable examination you could do as the value of the use of this launch pad over 20 years?
There's no market value for it because, according to the evidence in the record, because there's no market for it. There are no competing purchasers. There's nobody eager to buy a balloon launch pad. So the only value the county's been able to come up with to say, well, here's the consideration we received for the launch pad is Worldview's maintenance cost. Worldview's maintenance cost is about $12,500 a year, which is 156th of the value of the construction of this launch pad. That's gross disproportionality. Now, we're not.
But the difference between the launch pad and the rest of the facilities, the launch pad at the end of the deal is retained by the county, right? It's not part of the purchase option.
That's right, Your Honor.
Well, I've got you on the hook, and this is going back a ways. You mentioned two numbers that we're supposed to be comparing, 20 million and 11 3/4. 11 3/4, that's the 2016 value, the value in 2016 dollars of the payments.
I believe that's correct, Your Honor.
The 20 million is?
The $20 million is the 2016 values also, so far as I recall. We had to reduce.
2016 values of.
That's the $4 million Jeeplet. That's the $14 million remaining in the value of the building and fee. That issue brings to mind, I should mention. So this case presents a dilemma to the court because either this is a loan of credit, in which case it's unconstitutional, or it's a purchase over time. Or it's a lease, right? Either it's a lease or it's a loan. The county's position is this is a lease. If it's a lease, then the acquisition of the building at the end of the 20 years is an unconstitutional gift because the lease acquires no fee interest in the building. But Worldview obtains that $14 million fee interest for a token payment at the end of the deal, in which case that's gross disproportionality. On the other hand, if this is a sale over time and not a lease, but rather, then what it is it's a loan. And if it's a loan, then it's a loan of credit, an indirect loan of credit by the county in order to, again, to quote the language from the county, front-end capitalization of Worldview's private business.
Getting back to my question about the 20 million, you're including in that, you said the 14 million the building's worth at the end of the deal?
That's right, Your Honor.
I thought, aren't we supposed to be comparing the 11 3/4 that Worldview is paying to what the county's expenditures were?
No, Your Honor. What we are supposed to
The give and the get is from the entity's perspective. What did the county pay? What did the county expend versus what the county's getting in return? Isn't that what Shire stands for?
No, Your Honor. What Shire says is we compare what the public is giving with what the public is getting in the deal. That does not mean expenditures, and it is not focused exclusively on what the government entity is doing. It also
I understand your argument now. I misunderstood what you were arguing. So, okay.
It also depends on the fair market value comparison means that we have to, one point I wanted to mention is that this considers the factors I mentioned before. We compare we have to protect the public fisc and prevent the giving of money or other valuable advantages to private entities. In Shires, at page 37, or 377, rather, the court says, a private business will usually, if not always, generate some economic impact, and consequently, permitting such impacts to justify public funding of private ventures would eviscerate the gift clause. Now, the reason that quote is important is because that occurs in the consideration part of the Shire's analysis. That's not just a public purpose question. That's also a consideration question. Is the public getting back benefit in exchange for the expenditures or other forms of subsidy, other valuable advantages that the public is conferring on the private party? If there are no further questions, I'd like to reserve the remaining time for rebuttal, Your Honor.
So Grady, whenever you're ready.
Thank you, Your Honors. I guess I just want to back up a bit and walk through the gift clause analysis and obviously answer questions along the way, starting with public purpose, since that's where it usually starts. And here I didn't hear a lot of dispute or any dispute really that economic development is a public purpose. And that's why we have this agreement. That's why Pima County entered this agreement. And it's about generating jobs. It's about keeping this business in Pima County. It's about taking advantage of the opportunity for growth in this industry, which is innovative and fits well within what Pima County is trying to generate. And so we know that direct and indirect benefits count for public purpose. Economic development is a legitimate public purpose. So we check that box in the gift clause analysis. It serves the public purpose. Yes,
if I could, I have a perhaps it's just me, I have a little bit of a struggle figuring out what a court's role is in evaluating or determining whether something is for a public purpose. And when you look at shires, and with the utmost respect to the Supreme Court, I'm struggling with paragraphs 8 and 9 of shires, because they say it says it's elusive to define what a public purpose is. We're supposed to give it significant deference. We're not supposed to consider the wisdom of the expenditure. And we're not supposed to reverse on that point unless we find an unquestionable abuse of discretion. Well, it seems to me not considering the wisdom is an absolute bar to looking at the merits of public purpose. But then there has to be, how do we determine what an unquestionable abuse of discretion is? And how do we review the concept of public purpose? And I apologize for the convoluted way I asked that question. So.
No, that's understood. It's interesting in the Shires case, the case they cite when they're talking about where the governing body has unquestionably abused its discretion. They cite White, which is a gift clause case, but which also cites Sims v. Moore, which is an old case on public expenditures, where the government spent public money to influence an election, and the parenthetical comments that served a political purpose rather than a public purpose. So I think that might be an example based on the Shires case. I think if you're involved with self-dealing, which seems pretty obvious, if we're, building homes for, county people, that's an abuse of discretion, self-dealing.
But it's not unbridled discretion. There is some check on it.
Exactly. And that's what the courts say. There's going to be a lot of latitude given the elected officials. They're accountable to the public, and they're the ones who typically decide what's a public interest, and they're the ones who are accountable to the public for the wisdom of their decisions.
But the public spoke through the adoption of the constitutional provision of the gift clause.
That's right, Your Honor.
So why don't we listen to the public?
Oh, absolutely, we do. This is the framework that our Supreme Court has established for determining whether, on a case-by-case basis, these agreements satisfy those requirements or not. And the starting point is this public purpose.
Well, before 11-254-04 was adopted by the legislature, would economic development have satisfied the public purpose analysis, the constitutional public purpose analysis of the Supreme Court?
Yes, Your Honor, I think it would have.
Then what was the purpose of 11-254-04?
Well, one, I don't think it takes, I think more of county authority as a matter of statutory construction.
But the county was governed by the gift clause like the state was.
Right, but in terms of county authority to do so, it needs the statutory authority as well. And so I think it may not be a gift clause case, but you'd get maybe questions of county authorization to engage in certain transactions.
Okay, so it would have been, economic development activity pre-11-254 would have been thrown out because the counties weren't authorized to engage in that, or because it violated the gift clause?
Well, and I haven't gone back to the enactment history, but my sense is that the issues that would have been litigated might have been a county authority issue. But I think the enactment of that legislation helps support that the legislature authorizes, and certainly the Supreme Court recognizes that economic development is.
Yeah, I guess that's a question, but why should we let the legislature pass a law adopting an exception to a constitutional prohibition?
Your Honor, and obviously they can't do that, and they didn't do that here. They're recognizing it's a public purpose. Economic development is
right, but they're saying by this economic development is a public purpose, and we already know that public purpose was an exception to the prohibition on subsidies, because you can give a subsidy if there's a public purpose plus other things.
Your Honor, I disagree. Public purpose is the first step in the gift clause analysis, and then you got to move to the consideration
right, but for this statute, economic development wouldn't be an express public purpose.
I don't think we don't have, and the cases have never established, we don't have a laundry list of here are public purposes. And if you go back throughout the case law where they address public purpose, they recognize that that it evolves over time, that it's going to be established by the policymakers, And so it's been a flexible standard. There is no list. This is a public purpose. This is not a public purpose. It's developed as the case law has developed.
Oh, sorry. I have some questions about the nuts and bolts of this deal. You heard Mr. Sandefur say that the numbers were supposed to compare with the comparing the give to the get, so to speak, is how it's been referred to, or $20 million and 11.75. I take it you disagree? And if so, what numbers are we supposed to be using?
Your Honor, I appreciate the question. Yeah. So this consideration prong, we're looking at what does the government give? What does the government gift? And are these just grossly disproportionate? I think the trial court's analysis is appropriate here, where it looked at fair market value, which was the 14 million, a stipulated number as of the date of occupancy in 2016. So you have that fair market value number, 14 million. Compare that against, as the trial court did, the 11.75 or 11,750, which was that valuation of the lease purchase agreement payments, and compare those, and then you get into the question of, is there gross disproportionality? I'd also say that I think in the context of the panoptic evaluation, looking at a bunch of numbers is actually helpful. Looking at the city, what the city's investment was here,
County?
excuse me, the county. And again, we have the building property, and then we have the launch pad property. And I think the launch pad property is really a separate issue because
And that's a question I have as well. We've got this obligation to look at this thing panoptically. And I understand that the agreements for the lease purchase agreement for the other facility and the agreement with respect to the launch pad are separate agreements, but my understanding is that they each refer to the other and they were signed simultaneously. Is that essentially correct?
That's essentially correct. But
were they contingent on each other? Is there something in the agreements that said this deal only goes if the other deal goes as well and vice versa? Is that in there? And the reason, I'll be frank, the reason I'm asking this question is I want us to be clear as to whether or not our panoptic review of all this requires us to look at this as a package deal, or if it's possible for us to view one part of this sort of separate from the other, launch pad separate from the other.
The agreements do acknowledge both, and in terms of the terms of like a breach of one can be a breach of the other under the terms of the agreement. So there is some interconnection there. But I do think analytically, it also works to look at them as separate agreements because of the difference in property ownership.
Okay, well, let's look at that then. Let's look at the launch pad agreement. So Worldview is getting the use of the launch pad in exchange for paying maintenance and insurance on it, essentially.
It's getting the use of the launch pad, and this is available for others to use.
Okay. And if others do use it, it's at the discretion of Worldview, though.
Subject to commercially reasonable terms and county oversight.
And that Worldview, in agreeing to allow someone else to use it, can recoup from that other entity money not to exceed what they're paying in for the maintenance and that sort of thing. Is that right?
That's right.
Okay.
And
at the end of the deal, unlike the other part of this, the other agreement, under the launch pad agreement, Worldview doesn't have a purchase option. The launch pad is retained by the county. Is that right?
that's right. That's
Okay,
right.
So let's say we look at that as a separate deal. What are the numbers, if there are any, as to what the give and the get is under that? What the county's expended versus what the county's getting back.
What the county is, well, this is county-owned property, public property, so they're not, we're not giving away any public property as in either transaction, but this is and always will be county land unless there's a decision not to. So they are, the Worldview is taking on the responsibility for the care and maintenance of this property. It is a public property. It is available for public use. And we put in the record that, the interest that there has been in the use of this by entities beyond
But that
Worldview.
was post the agreement being inked, that there's been subsequent interest in use by other parties, right?
Yes, but the agreement contemplated that it would be available publicly. It wasn't built just for Worldview's use, and that's a requirement in the agreement.
Doesn't
It is-
Worldview have the ability, I'm sorry, Ms. O'Grady, doesn't Worldview, excuse me, have the ability to decide who uses the pad?
It has the ability to establish commercially reasonable, requirements. And then the county has oversight over the lease. Excuse me, not the lease, but over the operations agreement. This is basically an operations agreement.
It has a great deal of discretion in deciding what commercially acceptable uses would be. So they could say, for example, a competitor couldn't use the pad, couldn't they?
I'm not sure that would be acceptable to the county, because the county is, whether that the county would view that as fulfilling its obligations under the lease, excuse me, not the lease, the operations agreement. This is a public launch pad that
So
they are operating.
the lease payments that Worldview is making only covers the developed parts, right? The building, their building.
The separate lease purchase agreement covers the property with the building, not the launch pad
So
property.
the taxpayers would say that in the first 10 years, it's paying below market rent. I think the county's position is that over 20 years, Worldview will have paid market rent for that building. Is that, do I understand that?
That's right. And that's an example, Your Honor, of, looking at the transaction as a whole. You don't take it apart into different years. You look at the transaction as a whole. And here, I think even rather than the valuation of the lease payments, you're looking at the overall value of this lease purchase agreement, which was the approach taken at the trial court
And
level.
then the square footage, the dollars per square foot analysis done by both appraisers, that was based on, this is what this building would lease for in the open market per square foot. Is that,
They both put evidence
even though they
in
disagreed on the
that issue. And yeah, and then the trial court decided there was that there was no problem with the market lease
Okay.
on that point. And so maybe back to the give and the get a bit. And so the county is getting direct benefits, which is one of the distinctions with shires. We are getting rent payments over time, 28 some million dollars of rent payments to the county. This is county property. And yes, there is a lease purchase option on the developed building. And so the consideration question in valuing it is, what numbers do we compare? And we have the numbers in the record on the fair market value, on the amount of the investment, on the amount of the return. I know that appellants make much of Pima County's approach of wanting to make sure that all its investment in this project was recouped for the taxpayers. And there's nothing wrong with that. That's a good thing. That's a good thing. They're making expenditures. They're making sure that money is covered by these lease terms, that they're being made whole through this process. There is absolutely nothing wrong with that in terms of a gift clause analysis. I think it's a good thing in terms of the panoptic view of the facts.
And so Grady, as I understand it, the certificates of participation are repaid through lease payments, correct? But that's lease payments on all county land or just this particular item? And the reason I ask is, what happens if there's a default on the lease payments on this particular property?
Yeah. As I understand, the county has a variety of uses this certificate of participation as a financing mechanism, and it just refinanced that as part of this. And so it's my understanding, I don't believe it's property specific. I think it's that whole bundle of properties on which there are lease payment obligations. And I'm relying on the descriptions that are in the record.
So if there is a default, then they have to go get the money from other lease payments that they presumably receive from leasing other property.
And I think I'm getting out of my depth in terms of how that would work in that circumstance.
Well, but I have another question. I want to go back about 5 or 10 minutes if I get, you
Okay.
were talking about public purpose, and you said public purpose is the first step. And then we talked about the deference related to public purpose. Is it your position that the language of the gift clause, if there is a loan of credit, if the county loans its credit or gives a subsidy, in looking at the language of the gift clause, are those categorically barred, or do you look at even that for public purpose? Can the county, are you saying the county can loan its credit for a public purpose?
In our view, the loan of credit, which we don't think this is.
I understand
Understood.
that's your position.
Yeah.
Yes.
And we think the Worcester Shires test applies to all of that language. That, that you shall not ever give or loan its credit in aid of or make a donation or grant by subsidy or otherwise, that all of that is captured and covered in terms of compliance by
So you're saying there is
gift
no
clause case.
categorical bar in the Constitution?
In other words, as long, it can do all those things that on its face would appear to be prohibited by the gift clause, provided that's done for a public purpose?
Your Honor, the consideration prong as
I'm not talking about
applies as well.
consideration prong, I'm talking about the public purpose prong. I mean, does the I guess the question is, does the public purpose prong satisfy the gift clause? Standing alone, the answer is no, right?
You need both under current law. You need both under current law. Now, I recognize in the industrial development bond case at Pinal County versus Nelson, where the court approved of that under the gift clause. They rejected a constitutional challenge based on the gift clause. That was pre-Worcester. So it was mainly based on public purpose, but then also noting that there was no general obligation of the county at issue there, that it was only this dedicated revenue fund. And they approved of the transaction. And that is still cited as good law. And I think a lot of the cases from other jurisdictions that address this loan of credit, some of them come from that era. I'm thinking of the Port Townsend case and some others where they're dealing with these industrial development authority cases. And our courts, have upheld them under our gift clause as legitimate and not a constitutional problem. And even though that was done, when we just had the public purpose prong, although informed by, and I think this goes back to the original purpose of the constitutional prohibition, where they wanted to get rid of these 19th century transactions that were abused and that harmed public entities and taxpayers, and the protection there that the court recognized in the Pinal County IDA bond case was that this revenue bond structure, where there's no general obligation of the county at issue, it's all just the security by this transaction.
Mrs. O'Grady, I think I told Mr. Sandefur, I'm struggling with this loan its credit language. And I'm right up front. I know that you don't think this is a loan of credit. So I'm not suggesting that you're conceding anything on that point. From what you're saying, it seems to me if I co-sign my daughter's college loan, I'll get into experiences that I've had. If I co-sign my daughter's college loan, is that a loan of credit?
I would view that as a loan of credit if you are co-signing.
Okay. And your argument then, or the county's argument is that it could co-sign a loan or guarantee a loan for a private entity as long as it could state a public purpose and the numbers work.
And again, as you already noted, we don't think that
I
that
know, I
language
know, I know.
applies
I'm not,
here.
you're
So how would that
conceding nothing.
analysis work? Again, the court has never suggested a different test for that language. And it's, and so I think so you'd still need to, again, I'm getting the hypothetical with the college student out of my head. But if you have a public purpose and you've satisfied consideration, and I don't know what that hypothetical would look like exactly, then I think you satisfy this. I mean, this is strong language in the gift clause, and we have our modern test that tells us how to apply it. And so I think that's the test we need to apply to whatever transaction is being evaluated to determine whether it complies with the gift clause or not. And so I do think that's how you would do the analysis. It's not a per se prohibition.
What mathematical formula do we use to come up with gross disproportionality?
The courts haven't, given established one. We do know from the examples in Turkin are very extreme, $197 million for some parking places, $5 million to do a $5,000 sewer repair. Those are some of the examples cited. And we've given some other examples in the brief of that language in other contexts where you're talking about grossly disproportional. This is nowhere near the outer bounds when we're talking about a 16% differential. And so the court doesn't need to reach that. How far can you go? Because we're certainly not there here.
Well, it's the value at year 20 of this building is going to be 14 million, or is it 16? Not present value reduction, but
Thought it was 16 million,
Okay,
and
so
I'd have to
16
check.
million. And here they're buying it for 10, for $10.
Well,
Why isn't that the proportionality? I mean, what?
Your Honor, I think that's an example of needing to look at the agreement as a whole. We
Right,
don't
but
look at just the
you told me
$10.
the county has gained market rent over 20 years for this building. So it's gotten the market rent for a lease. Now we're in something else. Now the lease is over. County has gotten its lease payments for 20 years that it would have gotten from any other tenant. Now the Worldview gets the ability to buy this $16 million building for $10. Why can't we look at that? The rent for the use is a wash because it's market rent, so they paid for their use of it. Now we're looking at something else. Now we're looking at a different deal. Now we're looking at the value, what they're going to pay to then take ownership of this building. Why isn't it 10 vice 16 million?
When I don't think, two responses. One, the $11 million figure that we've been using here includes, takes into account that this is a lease purchase, and if they operate and if they exercise their
But you
option.
said the market rent did not. That market rate was just for the use of the facility, not for the purchase.
Well, we have the 14 million current fair market value. Then you have the lease purchase agreement value of the 11,725, which assumes no reversionary value there. And so that takes that into account. Even if you take into account
What was there a calculation done that didn't take into account the purchase option? That just said, this is what the value of the lease payments is to the county.
Well, we have
Like
the
20 million or something? Was it?
Well, we have the 28 million for the payments that without the present value. And then the 11,725 is effectively that because they don't add anything because they recognize there's nothing paid at the end of it. There's no reversionary value built into the lease. So
Was there a calculation in the record of what it would be with a reversionary?
there was a fair market. Well, some of the numbers included a present value of the estimated value at the end of the lease, which was about 3 million that they said could be added. And there were different values in the record for that reversionary value. And that would be added to the 11 million. It doesn't change the bottom line analysis of the consideration here.
Well, what would the value, what would the building be worth to the county at the end?
I believe, and I see my time is up.
Can answer.
Okay. I believe the numbers in the record were like 16.8 or 16, and I'd have to
And that's,
double
that's 2036 valuation, right?
check that. And I'm trying to check all my various numbers that I wrote down to see if that's right. I have like a 16.8 figure. And as one of the figures without a present value.
Right. So what then is would the value of the lease payments be just as lease, not as a lease purchase?
I think you end up with that 11,
Okay, so
725, if I'm understanding.
ignoring the power to purchase the building at the end of the 20 years,
Purchase.
there, $11 million is the value of the lease payments over time to the county.
The present value of the 28 million with the discounts with, all the assumptions that go into these present value estatements. Yeah, and because that didn't have any additional reversionary value. So that's
Well,
the value that they could sell that for, in 2016,
the 16 million,
the 11 million,
11, they
725.
could sell the building for?
Pardon me?
They could sell the building for?
That they could sell that lease purchase agreement for. And
Well, I'll let you go ahead and make your final point then.
honestly, I'm just here at this point to answer your questions. And overall, when you look at the agreement as a whole, the payments made, the payments received, the value made, the value that the property owned by Pinal County, or excuse me, Pima County, and also the fact that if they don't fulfill their obligations, this remains Pima County property. There is no gift clause violation by this transaction. People may question the wisdom. People may not like it, but those are sort of things for the elected officials. In terms of the gift clause analysis, it passes muster, and we ask this board to affirm. Thank you.
Sandefur.
Can I ask Ms. Sandefur first? Can you tell me, is it fair to look at this as a $10 exchange for a $16 million building, 2036?
$14 million, Your Honor, and absolutely it is. The values that Your Honor was asking about are on page 56 of our opening brief. You will also find in footnotes 21 and 22 our explanation of how that July modification works out in in these numbers. But we assume.
Interrupt you for just a moment on that. The modification, is that really before us?
No,
Because
Your
that
Honor,
was
we
something-
we
that was
don't
something
think so.
decided that was done after this case was heard by the trial court
And
after-
decided by this, right?
decided after the notice of appeal. In fact.
Totally agree, Your Honor. That's inappropriate to consider, but we thought we'd cover all their bases. So those values are that the use of the building is worth 11.75, we assume. Let's grant that and assume that Worldview is paying the equivalent value for the use of the building, which of course would be constitutional. On top of that, there's the $4 million Jeeplet, the $2 million cost to the county of building this launch pad that has no market value, so we're relying on the 2 million figure. And then the fee simple of the value that the county and we agreed to this value in the trial court, and it's in the trial court opinion, is $14 million in 2036, which is reduced down to $3 million in today's dollars. And those values are the values that this court should rely on. And I want to emphasize that treats the agreement as a whole. Your Honor asked about separating out the two contracts that are issued. We've never separated these two out. We've always treated these as a single thing because we're taking the panoptic view. Now, as far as public purpose is concerned, there's no need to address public purpose in this case, but I would point the court to the language in Shires. It uses a really interesting example. It talks about the hamburger stand. It says, the government can't fund the starting up of a hamburger stand on the theory that the hamburger stand is going to feed the community and that's good enough. That fails the gift clause according to Shires. And we submit to you that is financing the startup of a private business. 11254.04 cannot change the constitutional question here. There are two policies that this court applies in a loan of credit circumstance that differ from the Turkin test. The question came up about whether we apply that Turkin test to a loan as opposed to an outright expenditure. As we explained in our brief, it doesn't really work because the Turkin test is supposed to differentiate a purchase from a gift. You know, the situation where you pay $1,000 for a $10 hammer, so it turns out to be a gift. That's what Turkin is for, is to suss out those kinds of situations. Instead, in a loan situation, what you do is you apply the two principles that we talked about before: protecting the public fisc and preventing the giving of valuable advantages to private companies. That's what that test is failed plainly here, whether you regard this as a single contract as we do, or even if you take it apart and look at each separate element of that transaction. The purpose of the gift clause was to bar the government from front-ending capitalization of a private business. The county has admitted throughout this case that it arranged this deal in order to front-end capitalization of Worldview, and that's unconstitutional. Thank you, Your Honor.
Thank you, counsel. Matters now under advisement. We will issue a opinion in due course. I should advisedly say we'll issue a decision because it has yet to be determined whether it will be published or not, which does lead to a question I'd like to ask the parties. Publish on this?
Yes, Your Honor, please.
So Grady?
Whatever the court desires.
Okay. All right, thank you. All right, so that'll conclude the oral argument. Counsel, as I indicated, you're free to stay or go, whichever you prefer. I know you may.